Okay, good evening, everybody. We'll get started with our discussion now. My name is Michael O'Hare. I'm a professor at Marquette Law School, and we are here to discuss Cynthia Alcon and Andrea Schneider's wonderful new-ish book, Negotiating Crime, Plea Bargaining, Problem Solving, and Dispute Resolution in the Criminal Context. We have with us today not only the two co-authors, but also we're very fortunate to have Chief Judge Mary Trigiano join us from the Milwaukee County Circuit Court. So I have some questions that I'd like to throw at our panelists to get some conversation going. And then I hope to leave 5 minutes, 10 minutes maybe at the end for questions from the audience. So be thinking about your own questions. Before I start with the questions though, let me maybe exercise my moderator's privilege to share my own reaction to the book. As a teacher of criminal procedure, I can't help but think about this book primarily from the standpoint of its use by students. Law students as a textbook or a resource. And I think law students will find this to be a really terrifically rich complement to their other materials that they are studying in law school. As many of you in this room are very well aware, most criminal procedure textbooks focus on constitutional law and the jurisprudence of the United States Supreme Court, which, fascinating though it may be, provides you with a radically incomplete picture of the choices facing practicing prosecutors and defense lawyers and trial court judges. So the choices, the options, the pitfalls facing these actors in the system really are a world away, I think, from the picture painted by the high and mighty justices. And the real contribution of, from my perspective, the real major contribution from Andrea and Cynthia's book is to fill in that picture, providing a much richer sense of the options that are available to the practitioners in the system. All right, well, that's my initial take on things, but let me, Cynthia, ask you if you wouldn't mind explaining a little bit about the genesis of this project.
It goes back many years. Is this working? Okay, yeah, okay. When I first started teaching, which was a while back now, I developed a class that at the time I was calling dispute resolution in criminal cases, which is not too dissimilar to some of our title. And there was no material. There was no book. And I was creating the class essentially out of whole cloth. I was having to find and pull it together. And year after year, it got a little bit more refined and a little bit more, but it became clear to me that no one else was really going to pick this up and create a text for me. So if I wanted a book that could be used, it was really, I was going to have to take a little bit of charge of the situation and get it going. And that's, of course, when I approached Andrea, who's written many of these books, and asked if she would be interested in joining in this project.
So Andrea, tell us about the subsequent evolution of the book.
Well, so this is a really good story of where lack of knowledge should not keep you from doing anything. Because I knew nothing about criminal law or the criminal legal system. My extensive criminal experience had been summer clerking for a judge with a bunch of criminal trials in which he told me that by the time I saw them in trial, they were guilty anyway. And I really didn't need to learn much more about criminal law. And I'm like, oh, okay, fascinating. And that was one of the summers in law school. And kind of put that aside. And for those of you that have had me in ADR, you know that we, although we have one plea bargaining example now, sometimes that we do in negotiation class, that much of dispute resolution has focused on civil cases. And sure enough, that was my background as well. So when Cynthia approached me, it was very much though, like, I know how to write a textbook, but I have no idea what you're talking about. And that was great. I mean, it was a huge opportunity to dive into something and to learn something new.
Okay, and how about Chief Judge Trujillo? Do
You can just call her
yeah,
Justice.
Justice,
you know.
Justice.
Not what you said about justices just a minute ago.
What do you see as the value of a work like this for lawyers or people who are soon to become lawyers?
Sure. First of all, I need to see the book.
Oh, okay.
This is the first time I've actually touched the book. I met with Andrea several times down in the cafeteria, and I said, I want to teach a class here, and I want to teach a class on problem solving courts and trauma. Because I had been working with several people on some of those issues for a lengthy period of time, and she said, okay. I mean, we brainstormed down there, but I didn't have a book. So it was pulling together article after article after article to create this curriculum on problem solving courts and trauma. And she says, well, I have this book. And I'm like, I need it. And I need it yesterday. And so I ended up with some of the unfinished chapters that ultimately got finished, but the book wasn't quite finished when I first started teaching back in 2018. But to me, in particular, problem solving courts spoke to what I wanted to do as a judge when I wanted to become a lawyer. I wanted to help people. I wanted to be a problem solver. I wanted to, make people's lives better, which probably you all have said to yourselves at some point in time. And I found the regular system, the traditional system of justice, a really difficult way to do what I wanted to do. So I remember the other law school is where I went. I took dispute resolution courses. I fed myself with so much information on how to do things differently that it was a natural fit for me ultimately when I came to find myself teaching on these kinds of issues. So this book was fabulous. It does give you a unique perspective on the justice system. But I have lived in this system for a while, and it is changing and evolving and fitting within the confines of what this book teaches.
Want to maybe explain for people who aren't familiar with what a problem solving court is,
Sure.
like how exactly that differs from a conventional court?
Sure. So problem solving courts have been around since I think the first adult drug treatment court was Miami-Dade in 1989. And since then, right, there's probably, it's grown to about 3,000 courts across the country. Milwaukee in particular has about 6. But they are specialty courts. They are designed with a particular focus and a particular person or in mind that you want to help, usually around substance use disorders, mental health issues, domestic violence. We have one out at Children's Court, which focuses on infant mental health, so even babies and their mental health. And there are best practices associated with these courts, and if you follow them to a T, you usually have really good results. And so those practices, I'm going to name 3 of them because I think they're the key importance of them is it's led by a judge. So the judges use their leadership skills to pull people together, to have conversations about how you're going to focus on any particular individual, moving them into a better direction, into recovery, taking care of their mental health, et cetera. It's premised on a team approach. While the judge might be the leader, the judge also sits and rolls up their sleeves with a group of individuals, whether it's the prosecutor, the defense attorney, treatment providers, a variety of people, to say what kind of wraparound services are we going to put in place to help any particular individual in front of that court either get into recovery or have a stronger family going forward. And then the third and final piece is you really need the treatment modalities in place, right? If you're going to be treating individuals with severe and persistent mental illness, substance use disorders, you're not going to do that on your own as a judge, right? You're wanting the experts in place to really be able to say, here are the services that we think we can put in place to help you be a stronger individual and not end up back in the system again. So that's in a nutshell the problem solving course.
Okay, great. So the book covers problem-solving courts. My recollection serves, the largest portion of the book is about plea bargaining. And gosh, has there been a lot written about plea bargaining. And when it's from law professors, it's normally extremely critical of plea bargaining. What do you guys have to say about plea bargaining that's new?
I'll let you start with that.
So I think a lot of the folks who've written about plea bargaining, scholars who've written and made, written some very important and good works about plea bargaining, have taken it more from the criminal procedure perspective, and they've been folks who have done lots of scholarship more with the looking at it from that perspective. And I think the difference that we bring to it, I was a public defender in Los Angeles. I was a practicing lawyer for a good number of years. And I also have a master's in dispute resolution. And so for me, looking at plea bargaining from the perspective of negotiation and what does negotiation as a field bring into our thinking and our understanding and our possible improvement of is something that there has just been very little writing about up until not too long ago. I mean, here at Marquette, one of the reasons I was approached Andrea is because she did really, I think, the first conference that brought together, was a symposium Marquette Law did back in 2006 on looking at plea bargaining and how criminal cases were being processed, bringing in that dispute resolution perspective. And it was really the first bringing together scholars from crim and from dispute resolution, bring the silos together to have serious conversations and to learn from each other. And there are few people who have feet in both worlds. I happen to be one of them. One world or the other. And really a big part of our goal in the book, and half the book, you're right, is about plea bargaining. So it is a substantial part of the book. And a big part of our goal is to bring these worlds together. Negotiation scholars and practitioners have much to teach and much to learn about plea bargaining, and the same with criminal law practitioners and scholars. Much to teach and much to learn. And so when we bring them together, I think it brings everyone a little bit further in understanding the dominant process through which we're resolving criminal cases. And I think the early scholarship is, I know Professor, well, we talked a lot about plea bargaining with the expectation that we would ban it somehow, that we would do away with plea bargaining or have stunning changes to it. And I think what we've come to realize now is that's highly unlikely that we're going to see this big wholesale changes. So we have to figure out within what we have, how do we improve it? And what are some realistic things that we can do both at the practitioner level? How can individual prosecutors and defense lawyers become better negotiators and work better within this process? And then at a policy level, how can we do better? What improvements might make it process more fair?
Things that, I mean, two different things listening to you talk about it. One was kind of early on in the, again, lack of knowledge that I had, early on studying lawyers in negotiation and noticing that as a practice area, right? One of the analyses that I ran was lawyers by practice area and how did they negotiate in different styles. And that criminal lawyers seem to be much more cooperative. And recognizing that I had no idea why. And really, and again, kind of, looking back, is that because there's a lot of repeat play, they all know each other, you build your reputations, you get along, do you tell yourself this nice story of like, oh, when you work with people over time, everybody gets along, it's magic. Or is it because public defenders have no power whatsoever? Prosecutors are able to extort whatever they want. And there's, you have no choice but to be really cooperative with the people who have all the power. And that prosecutors don't perceive a power imbalance in the first place, and public defenders are smart enough not to complain about it. Right. And those are really two different stories. And I think that's where, my first article back in the symposium kind of left off like, here's some interesting data. I have no idea, right? Like you people figure this out. And so I remember reading Cynthia's work, around that time. And then within the next 15 years, of really looking at the elements of plea bargaining that, even the time pressure, right? Like we as consumers have more ability to back out of an airline ticket than a criminal defendant has to back out of a plea. You're like, wait, what? Right? Like a prosecutor is able to put time pressure of like, this is an exploding deal, buy now, by midnight or else, whatever. And stuff that would never be tolerated in the civil world in terms of either high pressure sales or, perennial used car salesmen or anybody else that we would kind of see as having all the power. We permit that in terms of prosecutorial tactics. And there's unbelievably little oversight, which was, again, something kind of striking to me, also looking from the ethics side of what we're expecting from lawyers and ineffective assistance of counsel, and that, again, really little oversight in terms of managing when lawyers are misbehaving, when prosecutors are misbehaving, and it just seemed a lot like a mess. So this book started, I think we had like 3 plea bargaining chapters and like 2 on problem solving courts and 2 on restorative justice and 2 on juvenile. And that plea bargaining just, I felt like it was, nope, we need a whole nother chapter on that. Nope, we need a whole, like, I didn't know that. We need more, more work in the book in order to really explain the details of what was happening on the ground in plea bargaining.
Good.
Yeah, so I everything they said. I would also say the chapters that I like the most, of course, were the problem solving courts, restorative justice and that, but I thought the most fascinating was the chapter on plea bargaining, right? So I'm coming in from the standpoint, so I've been a judge for 17 years. I practiced civil law before that and civil legal services as well after my law firm practice. And so when I came in, I spent 9 of my 17 years in children's court, and then a really small time frame in misdemeanor court, and then 3 years in the 3+ years in the domestic violence court, which is a kind of a problem solving court, and then civil, and then I became chief judge, and I don't have a calendar at all. And so the plea bargaining stage was interesting to me. And the most interesting piece, what you guys said in the book, which I agree with, is if you're going to get to an end result, you can get there through plea bargaining, or you can get there through problem solving courts or diversions or DPAs. What you're all trying to do, right, is figure out this human being in front of you. How do you protect the public? How do you rehabilitate the defendant based upon the severity of the offense, et cetera? And I think the most interesting thing from 10, 20 years ago right now is there's a menu of things that you have in front of you as a court system. And at least in Milwaukee County, I think we have a lot of the prosecutors know that menu, at least they're being trained on it, along with a defense bar and the judges, that you can take this tract and get a deferred prosecution agreement or a diversion agreement, and then if you successfully complete it, you don't have a record. We can get you in the problem solving courts if you have these kinds of problems, right? Or if you don't want any of that, there's your traditional plea bargaining track, and here's what this is worth, and here's what this is worth. So there's a very much of a smaller menu. So I think people are buying more into the problem solving courts, especially because the outcomes seem to be better. But I thought it was interesting because the plea bargaining probation may get you to the same point as the problem solving courts, but you have more supports watching you and you have more success than over here in the plea bargaining. Does that make sense?
Yeah, so once upon a time, let's say 200 years ago, everything went to trial. And then plea bargaining develops as an alternative to that. Now, plea bargaining's been around a long time. And more recently, we have another alternative, which is the problem solving court, another alternative to the traditional trial model. And then your book discusses another, which is restorative justice, which is something we haven't touched on yet. Andrea, maybe explain the difference between restorative justice and problem solving courts.
Sure. So restorative justice operates in a couple of different places. It can operate before as an alternative to prosecution for sometimes minor offenses, sometimes for juveniles, more like community prosecution. Sometimes it will work that way. Sometimes it's occurring. We've done restorative justice, as Michael knows, in the prisons where it's post conviction and you're serving your sentence, and we'll work on restorative justice. But the entire idea of restorative justice is really looking at it through both the victim and the offender's eyes, but really bringing the victim into either the exact victim or other kinds of victims to talk about the impacts, the harm on the entire community. So recognizing that any given crime, and we'll just use whatever the latest attack is on Marquette's campus, right? Like, it's not just that one Marquette student was pushed down and their goods, their phone was taken and they had a gun pointed at them, which is no doubt completely traumatic for them, right? It is traumatic for them. It's traumatic for their friends who they go back and tell. It's traumatic for their parents who trusted Marquette to take care of them. It's traumatic for every student nearby who now says, what, at 7:45 at night, I'm not supposed to walk on what block because I did that last night. Right? Like, those ripple effects of everything, let alone to, I imagine, our chief of police, who is an amazing woman, is also feeling the ripple effect of like, oh dear God, what am I supposed to do? And are we supposed to be policing every single block, right? Those are all of the ripple effects of the community. And that's not even talking about the defendant who, when they get caught, if they get caught, but when they get caught, are then potentially removed from their family. Were they a breadwinner for that family? What is it like to put that person in prison? What is it like for their family and their community to remove them for a very long time from their community? Because when we put people away, we put them away for a very long time. And really understanding all of those impacts, potentially sentencing differently, potentially having conversations about impact where the victim gets to talk about the impact, the community shares impact. Perhaps there are instances where prison is not the right response. I'm not saying that the person who rips off phones from Marquette kids shouldn't, whatever, but right, thinking about how are we best making the community safe. And so I think restorative justice, it is different than problem solving courts. But again, depending on what the crime is, the prosecutor, the facts of the case, that too can be a really interesting alternative that in many instances can be much more satisfying for the victim and can be more repairing for the community in the long term. So that's another thing that, again, we have taught here. We hopefully will teach again, and it has interesting options for us, I think.
Want to say something, Judge?
No, I would say that a really good problem solving court would have as a component a restorative justice component, because what you're also trying to do for that particular person in the court is make them understand the impact on society as well, as a healing measure for them as well as the victim.
We've got a bunch of options here that are to some extent overlapping: plea bargaining, problem solving courts, restorative justice, the juvenile system, which we haven't talked about very much. But thinking about the different options that are available, this extensive menu, as the judge referred to it, what seems to you the most promising, and what seems to you the most problematic? Cynthia, you want to start?
So I think that they all have promise and they all have problems, right? And so maybe I'll explain a little bit, not just stop there, right? So plea bargaining, because we in this country have so little rules around plea bargaining, it creates serious problems. We have concerns about how defendants are treated. Are their rights being protected? Are we doing anything resembling justice through the plea bargaining process? And also, because we have so little rules, problem solving courts were able to start because all it really took were prosecutors, judges, and defense lawyers saying, let's do this. We didn't need laws. When you look at how problem-solving courts have developed in continental Europe, they need laws before they can do this. And it slows things down, and it also slows down just trying something new and seeing what this, 1989 in Dade County, Florida, it was an amazing experiment that has taken off and has helped a lot of people. There's some concerns, but it's helped a lot of people at the end of the day. And it has changed how we think about our courts in important ways, right? We're no longer just about punishment, which when you look at 1989, how courts were, criminal courts in this country, it was punishment focused. We are no longer just that, right? And so the possibility to try new things through the flexibility of plea bargaining gives tremendous promise at a time when we have about this. We have the highest incarceration rates in the world by far. And if we only do small fixes around the edges, we will continue to have the high incarceration rates around the world. Seriously about serious change, and that without necessarily having to do immediate legislative change, which is hard. I live in Texas, it's hard in Texas. You live here, it can be hard here, right? I mean, we have challenges at a state level. And I think it's important to remember when we're talking about how our criminal legal system works, it's predominantly about how it works at a state level. And every single state is its own, and every single county can be its own in terms of actually working. And then when you look at things like the problem-solving courts and restorative justice, I think we've barely touched the surface of what we can do with restorative justice, of how it's working and being brought into and used in the. It's basically not being used at all in Texas, the second largest state by population, in a pre-conviction way. There's tremendous possibilities to do more. And the problem-solving courts, I think also, I think one of it's got tremendous promise, and one of the challenges with problem-solving courts is the model has stayed within these courts and has not gone wider. Aren't we looking more widely in all of our courts at what we can do for rehabilitation and therapeutic treatment? Why do we only put it in these courts? So I think there's tremendous potential and promise within those courts to do more. Haven't really touched on juvenile justice at all, but talk about an area where we really need to be making some fundamental changes. But I think it's also important to remember that juvenile courts were the original problem-solving courts. The whole idea of juvenile courts was to do better for kids. And I did a bunch of work abroad in the former Soviet Union and Yugoslavia, and there's a whole lot of countries that don't have separate juvenile courts at all. Juveniles are put into adult prisons. So, it is an improvement when we're not doing that. And yet, we've seen, a complete, shift away from, I think, the therapeutic origins of our potential and need to do much more.
Listening to you say that, I wonder, imagine if we had juvenile courts that extended until age 25 and until your frontal lobe was connected, which would handle like the vast majority of crime, period. And that's always been, one of the other things that struck me, other things I've learned while writing the book, right? One of them was looking at the problem-solving courts, and on the one hand going like, oh my God, this is the most amazing thing. I remember visiting Judge Trujillo's family drug court back in the day, and just going like, oh, this is magic. Everybody needs to do this. This is the best thing ever. It really is magic when it works. And if I were a criminal defense attorney, I would tell my client to find a drug problem now, immediately, so that they could go through drug court, because otherwise.
Would you say that to your law faculty colleagues as well?
Well, we might, after 2 years of the pandemic, already have that solved. Right? But the problem-solving courts are only available if you fit this lovely, beautiful little box of you have a drug problem, you have a mental health problem, you're a veteran. In other jurisdictions, there's teenage girl court, there's, you pick the group of people who you feel like helping. But that means that the vast majority of our criminal defendants who are young and poor and minority are not getting into these specialized courts. And there are mental health issues and poverty issues and all sorts of things that could use all of the bells and whistles that treatment courts provide. And so really, I'd love to see us figure out how we bring so many of the services that we provide in problem solving courts, it's expensive and on and on and on and on. But imagine if there was, the recidivism rates, which are very low, when somebody successfully completes those treatment things. I mean, that's why it works, is that you're getting people out of the system once and for all. So again, that promise of it, but the downside that we can't put everybody through it yet.
Everything we offer in problem solving courts should be offered before they get into the justice system. I just want to put that out there because it's mental health treatments, AOTA treatment, substance use disorder. It's trying to get people into pro-social behaviors. It's 1,000 things where, the judges just with the others in the treatment team just got frustrated, right? With the revolving door, and we can do better. And so if they're not going to do it beforehand, we'll use our discretion to build and create these courts where you get those wraparound services, right? I mean, I spent 9 of my 17 years in children's court on purpose. It was because that is the original problem solving court. And that's where I thought we could do the most good. So while we do have a family drug treatment court and a healthy infant court now, in those courts as a judge, you can do, different aspects of the treatment courts every day of your, existence in those courts. You have the power to call in for treatment providers and do certain things. So, taking from the example of the juvenile justice system or child welfare system, we have expanded it in some ways. It's just not a formal expansion. The other thing with treatment courts and so the expansion is hampered by a variety of things, right? A big thing it's hampered by is enough treatment services in the community to address all the needs of those in the system. And that's not on us, although we advocate for more and we're supportive of that on an ongoing basis. But it's really difficult. Even the existing treatment courts, we don't have enough treatment providers, the right kind of treatment providers, right, to get the job done. So that is an issue. And we don't have to have a law to change it. In fact, we have bipartisan support where they're putting legislation together so that there's money available for anybody who wants to start treatment courts, assuming you follow best practices. I think one of the issues that needs to be faced is not all judges and not all lawyers should be practicing in treatment courts. You have to have the right kind of judge. You have to have the right kind of lawyers, and so that you have to be very careful about following best practices, which is really important. I was going to say one more thing and I can't remember. I think right now it's not a fad. It's here to stay, just like restorative justice, just like everyone thought alternative dispute resolution was a fad, right? So every year, every 10 years, you'd hear somebody say, oh, that's just kind of a new thing, that alternative dispute resolution. No, it's not. It's been around for forever. And I do think the world is changing. Oh, I know what I want to say. One final thing on it is we are so backlogged right now in the criminal justice system. And everyone's saying, well, just go negotiate, get rid of these cases, negotiate it away so you don't have to wait for a trial. And some are saying, I want to wait for a trial. So I can't wait to see what's going to happen when we finally really get everyone back and get all the number of trials going pre-COVID with the backlog, because we have to be more problem solving if we're going to deal with the backlog. Otherwise, we'll never be able to address it. We won't. So it'll be interesting.
All right, well, we've got a couple minutes for questions from the audience. What would you guys like to hear about or talk about? Any
We were
brave
so
souls
good.
out there? Yeah, Mike.
That's too opaque.
Sure.
Hang on just a second. Eric, do I need to repeat the question?
Okay.
Yeah, okay. So the question is about what would make somebody the right kind of judge or the right kind of lawyer?
Sure. I think you have to be willing to learn an awful lot about human behavior and understand it to be able to really buy into what we're trying to do in terms of getting people into recovery. I was just reading an article article, I think it was in the New York Times, something about flawed humans, flawed justice system, right? Because our whole justice system is based upon what we believe behavior should be, right? But it really isn't that when you look at it and you look at the brain science behind people's conduct and how trauma and stress impacts how people respond to certain things. So I think the problem solving courts is an attempt to understand that better, understand human behavior. And if you understand human behavior, you can move people into better outcomes. So intellectual curiosity about those things, I think, is super important. You know, a willingness to collaborate, to build consensus, you know, to understand the system as it is and how it could be better. Getting along with people, because you got to sit there and work with people day in and day out that you probably didn't think you'd be able to before. You also have to, and I always say it this way, you have to be able to pull yourself away from, so you're an advocate, right? You have ethical rules you have to follow, but you have to be comfortable to be able to say, as one of the defense attorneys says, I think my client needs a timeout because, you know, they used yesterday and I don't think it was appropriate. And then the prosecutor getting up and saying, they didn't use to the level they did last week. So I think we're okay. We're making progress. And you'd never hear that in a traditional court, right? So you really got to think critically and outside the box around what to do around this human behavior issue. That's a good question.
Interesting.
And
Other
go to my
questions?
class when I have it, if I ever get it back again.
But you say the word. I mean, how many of you would like to take this class from Judge Trujillo? I mean, come on, 2 L's, get that hand right. So what else? Exactly. We need her back. So we need the backlog
They're
to
still
disappear
nervous
so
about
that you can come back into the classroom.
We'll report back to Dean Kearney that 30 hands were up.
Exactly. Absolutely.
They're not sure yet. It's okay.
Other questions for our panelists? Yeah. So the question is whether we could have a story to illustrate this, and maybe in the interest of time, one story. Does somebody have something
Oh,
quick in mind?
I maybe have a story that speaks to why we need to think differently, and why all these alternative processes matter so much. When I was a public defender in Los Angeles, I was charged with attempted murder. She was 19 years old. She had shot her sister.
I love the story.
And was charged with attempted murder because she had shot her sister. Her sister survived. There weren't serious injuries. My client, who was 19 years old, was pregnant with her 5th child. The prosecutor who was assigned the case, it was when I was working in the Compton court, was the prosecutor who handled cases in the domestic violence and sexual assault unit that they had. And I wasn't quite sure why it had been assigned to that prosecutor. So I asked, and she said, well, I know your client. Your client had been a victim in a case that I handled a number of years ago, when her father was charged with sexually molesting her, currently serving 30 years in prison. My client's sister, the victim in the current case, had refused to testify. The mother of both of these girls had not wanted my client to testify. There were a series of family problems that happened as a result of their disagreements about this case and what they each had chosen to do. My client had 5 children. The first 2, their father had been killed in a gang-related shooting. He had been shot in front of her and died in her arms. The father of the second 2 children was killed also in Compton. Compton had the highest murder rate in the country. And she was not there at the time of the shooting, but someone told her that he had been shot, and she went running to the scene and died in her arms. The father of the 5th yet to be born child was in prison. When I first met my client, she couldn't say anything coherent. She was in such shock and such a state of just emotional trauma. There's no other word for it, really. I couldn't get any information out of her. It was not an effective, client interview at all. And I had enough sense to know that I needed to appoint an expert to talk to my client. So I appointed a psychologist who was able to spend time with her and get information out of her. And the report said that at the time the Bosnian War had been going on, and she said, and there'd been refugees in Los Angeles, that I have not seen anyone who has suffered the level of trauma that you're coming out of war zone. In addition to the fathers of her children, she had friends and family. She had 20 people that she'd known in violence in Compton. And the question, what do you do? Standard criminal court responses are inadequate to that situation. Have a young woman who's in crisis. She's got children who, by all accounts, she's a good mother to. No one was saying these children were neglected. There were no reports of that. She, when I was able to start having conversations with her, she clearly loved her children dearly. What do you do? Sending her to prison for attempted murder is really not much of a solution in this. Now, fortunately, I had a prosecutor who had a deeper understanding. She knew my client. She'd known her longer than I had. And she felt for her in a way that I think doesn't often happen. And at the end of many months, nearly a year of working on the case and sorting out help for my client in terms of housing and assistance for the children and all the other things that she did, we were able to work out a deal where she got time served and probation. And we had housing that was away from her mother and her sister and that toxic situation to her. And when she came for her first progress report in court, by then she had a fifth child, and all of them came into court. They couldn't have been more beautifully dressed or behaved. And she was doing everything that she should. And, as far as I know, they were moving forward, right? And this is what we'd like to see, I think, all of us. This is like to see that people, can move out of these difficult situations and better, and that we're not just singularly focused on how do we punish that first story.
That's tremendous. Our time is up, so let's wrap it up, and please
That's not
join
a-
me in
That's not a
thanking
rare
our
story.
speakers.